Michael Cousins, hello.
Hi,
Thank you for joining us and helping us out today.
I hope I can. Yeah.
um, we'll just get started. My name's Stephanie Schubert. I'm the operations coordinator for Pacifica Network, and um, I'll be monitoring, or what do you call that? Not monitoring, but you know, doing the meeting
Facilitating.
today. And it's good to have all of you. And Michael Cousins is a lawyer. He's going to talk with us about copyright law, and John Almella from Pacifica Network is also going to talk with us. And for those of us who are just joining, John Almella made a very nice introductory packet on copyright issues, and I put that on as an attachment on the Zoom link. So if you hadn't had a chance to look at it yet, it is very helpful. And he's going to answer any questions people have. And there is a typo on page 2. He put free use, but he meant fair use. So that's just a note for everybody. So, copyright issues. Originally, we were just going to read the packet, but since we have the bonus of having Michael Cousins with us, um, I think I might be good to start with him. I don't know if you have a introductory thing that you like to say on this topic, Michael, or if people want to start with questions. I'm kind of gonna leave it up to you. I'll go to Michael and let you decide how you want to play it.
Okay, well, I looked at that introductory material that you circulated. I thought it was terrific. It covered a lot of the major points. It's hard to stay current because the rules for this keep changing, but there's one basic idea here, which is that music rights that are the rights that concern us in broadcasting music or in streaming music all harken back to a statutory license that's set forth in the copyright law. And that licensing scheme is administered by the rights organizations. And it's gotten to be now 3 layers, just to make it confusing enough. The first layer is the Copyright Office, where they deal with infringement issues. The second layer is the rights organizations, ASCAP, BMI, and CSAC. And the third layer is that a lot of this has been delegated to an organization called the Sound Exchange. So for many of our purposes, we get to ignore the rights organizations if we have a deal set up through the Sound Exchange where they have a fixed rate card of what you're going to have to spend. And then making the whole thing even more complicated, the Corporation for Public Broadcasting has come in and done a blanket license for CPB qualified stations. That has been added on to NFC member stations. So it's possible to get that initial expense of the licensing scheme that you see set forth in the rate card at the Sound Exchange covered by the blanket license at CPB. So those are all the building blocks. I don't understand them all completely. I don't know if I'm necessarily up to date with all the rules. And I know that the broadcasting scheme is really quite different from the scheme for streaming, which is a trickier business. And if you're not in the blanket license situation, the population, the size of the population within your 60 dBU contour may dictate whether you're going to have to pay a small fee or a large fee. So I've told you now about the limits of what I know about all this stuff, but I'll try to answer any questions that I can.
Hi, everyone.
Hi there.
It's Diana Basto. I'm on the board here, but I'm also a copyright attorney. So anything I can add to the discussion, happy to do so. Not trying to horn in. Just wanted to introduce
Not
myself.
at all.
Oh,
Well,
excellent.
yeah. I'm sure you know a lot more about this than I do.
There is so
I'm
much.
basically I'm in the regulatory field. I know FCC rules and regulations, and I do a lot of assignment and transfer. I do a
Sure.
lot of licensing. Copyright is kind of peripheral to my knowledge, so it's great to have you here. You can probably answer the question better than I.
Well, I'm in the room, fly on the wall, go for it. And I'm just, how many of us are on here? It looks like 20. So I applaud all of your showing up to get the background on that, which is why we can make a living.
Yeah, this is a great showing and a great topic. And I see Isabel has her hand up for a question.
Sorry.
Unmute.
Yeah, I was trying to, my mouse is sticking. Hi, Diana, how are you? And so I have one question really quick that comes to my mind. I always learned that you did not have to pay for all of the rights organizations, BMI, ASCAP, everything, that you just needed to pay to the fees for one. And so I don't know if that's right or not. And currently our radio station fees for that are paid by the university. So that's a blanket, I guess, license for any university use of the music, and our radio station falls under that.
Well, each of these organizations has its own stable of recording artists.
Mm-hmm.
So if you can somehow thread the needle and only broadcast material that's under the license of ASCAP or BMI, you can avoid paying the others. It's a question of whether they have rights that you're interested in. And theoretically, you can avoid paying them altogether if you deal with original artists who are not tied into any of them.
Right.
I would probably throw a little extra juice on that response, which is that, I've had some calls recently because there's some, let's just say, burgeoning new performing rights associations out there as to whether they are owed licensing fees. And this one in particular, I'm not going to get into the nitty gritty and details. I don't want to get lost in the forest for the trees, is that the expression? But essentially, a bunch of the really top name folks have stepped away from the BMI ASCAP group and are forming their own, and it's much more expensive. So the real issue at hand, as I see it, stepping back from what's been done in the past and just looking at the landscape today, is you have more artists who are taking control of their own revenue stream. Some of them are choosing not to be associated with BMI or ASCAP and are out there trying to allow no licensing fees to be paid. But that's not something that I would suggest you do without having some kind of arrangement or some kind of registration with what is it? For some reason, my mind isn't working completely today. The Commons, what is that group that basically allows artists to say that they don't want to get licensing fees for their works?
Creative.
Yeah, Creative Commons, exactly. But you've got four domestic United States performing rights associations, and each one of them are going to have groups of artists. And it really depends on what the tastes are and the breadth of your, what you're broadcasting. So that is unfortunate because it makes it unwieldy. And if you happen to have a large state university system that's willing to just say, let me just cover everything and I'll just pay them all, and I don't want to get lost in the details, that's great. But if you're not, and you're in a small school or in a small situation where they're being more observant and careful, then you have to be watchful that suddenly, you've got want to play popular artists that are not at ASCAP. I mean, on the flip side is if you just want to play public domain music, that was recorded people that don't want to, don't really care that much, then you're good. But that's, I don't know a single station that does that. So that's my 2 cents on the matter.
Very difficult to do that.
We have a question from Abin of, is that something DJs ought to be aware of, that their licensing might not cover popular artists in this independent rights group?
Exactly. And you don't want to, again, it's a time management analysis. Really, it's like yes, you have your composers that are the most reputable and the most widely known, that are going to stick with the tried and true ASCAP BMI type licensing, so that they don't have to get lost in the details. And then you have, you've got the piece, the composition, and then you have the artist, the performer, and each have their own rights. So that's why it's getting more and more complex. Would you agree, Cuz? You've disappeared from my screen.
What's really tough is that somebody who may be a talented on-air personality who's mainly playing music in a niche or across the board is not somebody who's trained to figure out this morass of rights. They're somebody who wants to play things that they think people will enjoy. And if you are trying to get them all the way through a training program where they're familiar with the whole rights system, I think you're trying to do an impossible thing. What you want to do is try to have the coverage that you need for the type of programming that you want to do, and cover as many bases as you can. And the fact is, no organization of right provision is going to be perfect unless it's a blanket license. There are going to be holes. There are going to be mistakes, innocent mistakes made.
Exactly. One of the things I suggest people do, and I don't know how friendly you are with your university administration, but there is someone on the legal team of your university responsible for intellectual property, and they should be well versed in copyright as well as trademark, as well as helping the science professors be able to, manage their inventions. And if they're not well versed in helping in the copyright area, you should make it known that that is your expectation, so that it's out of your hands and you have a professional there who's protecting the university for liability and costs associated with their students learning how to, run a vibrant, creative radio station, and lean on them, because that's what they're supposed to protect you for that. And the fact that there's a fee associated with it is secondary. It's like we want to play everything. So unless you have an issue, Mr. Intellectual Property Counsel for your university, this is what the fee structure is to cover that. And if you want to question it, your office can fight it, but we're here just to train our students. So lean on the folks that are supposed to be carrying the ball of that expertise at your particular university, and just guide your students to just say, creators are creators. Creators get paid, creators get licensed. These licenses are like pennies per play. It's really nothing that would be considered onerous, and move forward,
Well, Diana and Michael, there's a lot of people on this meeting who are not associated with the university or are part of CPB funding. What are the steps for unpacking this if you're kind of on your own to figure out how do you actually do the research that you need to know who you should be paying?
Well, I thought the briefing that was circulated for this meeting was really good. I would encourage you, if you haven't reviewed it, to go through it in detail, print it out, and familiarize yourself with it, because that's a great starting place for all these issues. Also, there's, I think there are copyright items for NFCB members. There are copyright items behind their membership paywall, and there's also a posting on this at the Prometheus website, though I think it's out of date. So there are ways to get around and familiarize yourself with this.
some of the you know, every time you buy, every time you go online and you look up an artist or a recording, they will identify who's the composer and who's the recording artist, and they will commonly have a stamp as to who is the publisher. Let's say Warner Brothers, Warner. Okay, Warner is an ASCAP house. My experience, 99% of their people are there. So, you know, there are ways to track whether it's going to fall under the umbrella of the Performing Rights Association you're paying licensing fee with. And there was a blanket licensing, like Michael was saying. It's not you pay one fee based, I believe it's on the size of your institution, or it's either the size of the institution or the size of the distribution net. And it's an annual fee. Would that be true, Isabel? That's my experience. Yeah.
Those fees are usually they have some kind of minimum fee, and then it scales up based on the frequency of play plus the size of the market within your contour.
Yeah, so to answer Diana, I don't directly have to handle that because the university has to cover it for the entire university.
Right, exactly. In other words, it's not just for the radio, it's for, you know, people
the
to get
library, the
concerts and the
classroom.
titles and everything.
Yeah, so thankfully, we don't have to pay that because
well, then your piece looks like
sound exchange. We do have to pay the sound exchange that we have to pay directly ourselves.
Got it. So I'm sorry about that. I didn't realize that there were people in here that weren't part of an academic body. So sorry about
Actually,
that. Thanks for the clarification.
most folks here are community radio and not per se university licensees.
Oh, thank you, Elliot. Or I think, I'm sorry if I wasn't.
Question from Sharon. At what age does a work enter the public domain? I see from John's packet it was any musical work published in 1924 or earlier, and then music generally enters the public domain in a period of 50 to 75 years after the composer's death.
That's not exactly true. Did you want to comment on that
Okay.
first?
No, go ahead. Go ahead.
There's been a lot of changes in copyright law over the last 100 years, let us say, or 110 years. The most important thing to know today is that if you were to compose a piece of music today and you were not writing it as a work for hire for a corporate entity, the copyright would last 70 years after the date of death. Okay, so I write a piece of music in 2021. I get hit by a bus this year. Add 70 years to that, 2091. If I wrote it for Disney to be put in Mulan 4. I wrote it for Disney this year, 2021, but it was for a movie that they released in 2030. The clock starts ticking on the date the music enters the marketplace. So the date it's presented in the world for your listening pleasure. And then I believe it's 95 years. I have to check that, but it's a completely different duration than in the corporate sphere than it is if the rights are owned by the artist and it's, you know, put out into the public right away. That's today. There are works that were written in 24 that entered the public domain January 1st of 2021. No, 2020, excuse me. That includes Rhapsody in Blue, actually, because I work on that case with that estate. So for works that were written in the 20s and 30s and 40s, there were changes made to the copyright law, and it's fairly complicated, and I think too complicated for like a 1-hour session. But there was a period of time where things fell off copyright protection, and then law was written that allowed them to sort of grandfather in for a duration of time. So I mean, it's fairly complicated, and it has to do with also with whether it was written for as a work for hire or written by yourself, written for your own under your own name. And the other element that has changed dramatically is it used to be the case that a work was not protected unless you registered it in the Copyright Office. And current law is the date you put pen to paper, you have a copyright. you have copyright protection and you can sue for copyright infringement. However, you're not going to be able to get damages for that infringement. The clock for the damage calculation is based on the date of your registration. So people come to me and say, I've written 50 things. What do I do? Blah, blah, blah. And I said, well, which do you think are going to be played in the marketplace? And perhaps those are the ones that you register versus spending the time and money to register everything because it's not being proliferated in the marketplace particularly. So that is another dramatic change in the way intellectual property law it works in today's universe, is that you have the right from the date you put pen to paper, but your ability to collect money that it's two-sided, actually. It's money the other guy earned on your music, and it's the money you didn't earn on your music. So you actually do a calculation on money lost versus their sales revenue, for a better word. Is that answer your question a little bit, Stephanie? Only because I don't want to go back and do like the 20s and the 30s and the 40s. It's a fairly complex answer when it comes to works written many, many years ago.
Yeah.
Whatever Disney company has done to make it bad, they will try to make it worse as they can.
Next question from Brian, WHYR at Baton Rouge Community Radio. We are the signatories to the CPB Sound Exchange 2021 to 25 agreement as a NFCB member organization. Are we legal insofar as we continue paying as a normal BMI, SESA, C, ASAP for terrestrial broadcasting musical composition rights and paying NFCB and Sound Exchange for internet streaming sound recording rights? Was that a big question?
That's a question that has to be like submitted in writing because there's a lot unpacked.
It sounds good.
It is in the chat.
Yeah, I mean,
sounds like
take my email.
Okay,
well, it's a little specific, just a little specific. But my common answer is you draw the picket fence pretty narrowly. In other words, whatever you paid for, I urge people not to presume that they get more. And I think the analysis here is saying, well, does one payment here cover these other attributes? So I'd have to take a closer look. Does anybody else have a similar sort of a intersection of these various fees and licenses across multiple performing rights organizations? I'm seeing a lot of nods. It's like, if I do this, do I get this? Do I get this?
That's the typical situation that hopefully you've signed up through CPB or NPR or NFCB so that you're covered. And it sounds like this person who posed the long question is pretty well covered, although I think they still could have a problem with frequency of play, which is an issue with Sound Exchange, that using the same artist or the same tune multiple times during a fixed period can be a violation of their rules for usage. I don't think that you, by signing on to their contract, I don't think that you're exempt from those criteria.
Does everybody in the room know what that means? You can't play Madonna Vogue like every 10 minutes. Wrinkle your musical experience across multiple artists. Okay. Sorry we couldn't, answer that question so easily, but requires a pretty detailed.
I think there's also a problem with, I have to admit, I listen to music on Sirius XM probably more than I do on terrestrial radio. I'm sorry, it's just it's a flaw that I have, but they brag on having programs where they play new released track by track. They call it track by track. Track by track is a potential problem in public radio because it does not, it's just playing the entire CD or whatever it is, the entire 75-minute release track by track, I think is something that's inconsistent with what Sound Exchange will permit you to do.
Yeah, Sharon says if you pay them for both online and FM broadcasting, you are covered. Sound Exchange is only required for streaming.
Not true. Sound Exchange is there to make deals for terrestrial broadcasting as well.
Mm.
Okay, then that's news to me. Anybody else want to? I was under the impression that, well, maybe it's different for non-commercial or LPFM stations.
I don't have the answer to that. I'm going to have to do some homework on that particular issue. I wish that I was, I mean, I agree as a policy, and everybody's, all of these things are there to distribute money to the artist, but also they need enough money to like cover their own internal expenses. And they want to be, they don't want to be in the hole. But I don't know offhand if there's been any changes with the breadth of licensing availability through Sound Exchange. I haven't looked at carefully recently.
From what I understand, terrestrial radio stations only have to pay artists, which is BMI, ASCAP, and the other one. And Sound Exchange is for songwriters. And I think that if you stream, you have to pay both the artist and the songwriter. I could be wrong though.
Well, you always have to. There always has to be money distributed to both. That's the what I call the birthday cake of rights. You've got the composer, you've got the brand of the band, if you will, and then under that you have work for hire agreements for all of the individual artists there. And sometimes when you do recordings, you actually have to get releases because a lot of those deals require exclusivity under the band identifier. That's some of the dealings that I am sort of trying to extract, is like within certain recordings, were there exclusive agreements so that other entities get paid to release that artist to perform on such and such a cut. Yeah, good point. Good point. I like I said, I am of the same thinking, but as the person that just spoke, I don't know who that was, but again, they, on an annual basis, I try to look at their, the fine print of their contracts to see if there's been a change in their responsibilities and what you're paying. In other words, either narrowing what you get or expanding what they want you to pay for. And I just haven't had a chance in 2021 to do that yet, but it's always good to check. There was a question in here, and I just want I'd forgotten we were doing this chat thing, and I wanted to, is Joseph Orozco on the line, or is he just in the chat?
Yeah, he's on the line, and I'll just say before his question that John Almella has joined us on the call too, who wrote the packet. So welcome, John, and thank you for writing.
Hi there.
Let's start.
I just want to make a brief comment too, just for a second to address the level of stress that I think we're all feeling right now. At least I am. One of my most memorable experiences of the Grassroots Radio Conference is when somebody didn't show up to do their workshop. And so all of us in the room that had come to see the workshop sat for an hour and for the 90 minutes allocated and told each other our stress stories about licensing. And we were all literally on the floor crying with laughter by the end because the stories were so horrendous and so kind of dumbfounding. And so, you know, I just wanted to acknowledge like how stressful this is. It certainly is for us, and I know it is for everybody else.
Well, I mean, this can be a horror show to the person who's in good faith trying to be in compliance, but also as a political thing, I think that we recognize that ASCAP, BMI, and are not really there for the artists. They're there for themselves, and the artists don't get a particularly good deal out of this system. And then CSAC is very interesting because it's smaller than the others, but it's a private company. It's not publicly traded. It doesn't publish its results, and it's very secretive, and it's more expensive than the others. And who knows what money goes in and who knows what money comes out with CSAC. And they tend to be the subject of lawsuits over some of these systems much more than the other ones. So
Lack of accountability creates a problem, sure.
the system that you're trying to deal with as a consumer is also kind of a complete mess when you pull off the top and look inside the system.
With that, should we go to Joseph's question here? Well, we got lots more questions. First question from Joseph. NCE tribal owned station, small population. We stream CSG/NFCB member. 3 podcast questions. Can a music show be podcasted on a station's website?
I don't, you have to define your terms. Linking to the podcast or where you can actually click on it on the station's website, or what? Or is it just a reference that you can look up?
Yeah, if no, it's the actual sound, the audio.
Yeah, I think I want to clarify here. The use of the word podcast is being used loosely often. Joseph, in this case, you're talking about just audio.
Okay.
You're not talking about podcasting literally, right? You're just talking about putting audio on your website.
Okay, let's define podcast then.
Okay.
If a program that we produce here is then put on our website where people can access it, not live. That's we stream as well, but
Yeah,
I'm talking about
archive
after the
rather
stream
than
tomorrow.
podcast.
You want to hear this show?
archiving. Yeah.
Yes, archive podcast. You want to call it that? Fine. That's
If I can-
this question.
If I can answer, what I've always been teaching is that a podcast, if you're streaming it, it's fine. But if people can download it, the actual file, then that's not okay, because the station is licensed to broadcast, not record and distribute. And a podcast has been considered recording and distributing, unless you have the copyrights permission for whatever music is played. Not if it's just
Oh,
vocal
Good,
words.
yeah, good
talking.
distinction. Yes. Good distinction.
yes. Thank you very much. Okay, then that's another one of my questions then. In the actual downloading of that, then what restrictions are there? Or
My
is it allowable?
recommendation has always been,
And for a short period of time?
my recommendation as a lawyer has always been that in order to, before you even place a podcast on your site to be available for distribution, just to even be available distribution, you need to get releases from the people on that podcast, or you do not have permission to make it available for download. I don't know what they do where Isabel is, but that has always been, I mean, and making releases are very simple, but it means the releases essentially state that you give permission for your own voice, your content, your words to be available for to such and such your radio station for distribution, and that you accept no remuneration. You're not waiting to get paid for anything as a result of 0 downloads, 500,000 downloads, anything else. That there's no, you've given your permission for free and available distribution of that podcast. Without that,
Oh, that's great. Thank you.
without that release or waiver of rights, whatever you want to call the document, they could come back and say, "Oh, where's my money?" where.
A
Yeah,
podcast
yeah,
is,
I'd like to know where my end is too, yeah.
Yeah.
But
no,
can I rephrase your question, Joseph? Because I'm a little bit
Well,
confused.
go ahead. Fine, fine.
So, okay, three things. Joseph has a audio file that has music in it that is not open source. It's licensed somewhere, or it belongs to somebody. Number one, he wants to put it on his website for people to listen to it and stream. Number two, he wants to put it on his website and allow people to download it. And number three, he wants to literally podcast that audio using podcast technology, which means that he's going to, have an RSS feed. Which of those are legal if it has music in it that he does not have, a disclaimer from the artist who owns the music himself? Which of those are legal?
well, let's start with probably the easiest one is
Excellent.
that if you have broadcast something on your radio station and then you're archiving it and somebody can go back and pick up the archive within 2 weeks. I think there's a limitation of 2 weeks in
Mhm.
sound
Yeah, I
exchange,
got the 2
for
weeks, yeah.
example. Not a problem, not a problem. But the idea of downloading the program as a whole, not as an archive, but maybe more like a podcast, that means that the program has been made available in a manner where you, the user, grab that program and have a semi-permanent copy of it in your possession on your phone or whatever. That is a publication in copyright terms, and it raises a completely different issue from everything that we've been talking about with broadcasting and even
So it doesn't really matter whether they downloaded it from his website or using an RSS feed. Both of those are essentially legally in the same category.
Can I ask a quick question, Ursula? This is
Yeah.
Diana. When you sort of laid out the framework of the three options originally, I think you said, and I'm sorry if I misunderstood, that in no instance was there a performance right or any kind of BMI, any kind of license paid to have the right to broadcast that music. Because if that's the case, then
Well,
none of these things
this isn't really broadcasting. I mean, we're talking about downloading.
disseminate. And search
well, then if there are no rights involved, then you're back to you have the problem immediately with the
yeah, there are
broadcast.
no rights. None of
down
them
the line.
would be.
Well, yeah, that's what I'm saying. If there's music in the show that is licensed, is that legal on any of those three? I mean, what I'm hearing you say is if people can download it and have the sound file, whether it's technically podcast with an RSS feed or whether they get it from his website from an archive, that's legally the same situation. In either of those situations, can licensed music be involved?
No, do you have the when you say licensed music, are you as part of
Say,
that?
Stevie Wonder,
You have paid a license to use it.
Let's say you
It's
put
copyrighted
in,
music.
yeah, copyrighted
Somebody
music.
has copyrighted that music.
Say you want to play Stevie Wonder's Ebony and Ivory in your podcast.
Ursula, you're assuming that the station already has the blanket coverage to play it on the station.
Yeah, that I don't think, because this is talking about downloading. So this is a different thing.
Right, but I think that the ability to post it for 2 weeks after you broadcast it on the station comes through your blanket licensing that you already have.
Yeah, you already have to have some
Beyond
kind
that,
of
I don't think
license
it's
to use it.
distributed.
The archive idea, yes.
Yeah, but the archive has to be streamed as well. It can't be downloadable.
That's what I'm asking. If you can download it, is that legal?
No.
No.
No. So
No.
if people can download
I heard
it,
that.
whether it's using an RSS feed or just by hand from your website, that's not. Is that in a way what you were asking, Joseph? Because I'm trying to understand your question.
Uh, well, it's actually it's both of them. The podcast idea, yes, okay. You're saying that we can't play copyrighted music on a podcast that it's downloadable. You could hear it. We could share that. Now, I also have like our Dying for Water production and our California Indian Radio project, where we had original music, and we also had a mix of some artists' music that was copyrighted, but they did give us permission to use it. Now that's on our website in our archives, and you can listen to that, and you can also download it. We have that capability of doing that, and I can cancel that capability if I have to. That's the other question that I didn't write, you know, because I'm dealing with a website master who may not know these details of copyright and broadcast law.
Well, when you say you have permission, that opens up another issue. I mean, is the permission granted in writing, and is it comprehensive for all media, or is it just a telephone call that you had with the artist who said, yeah, fine, use it any way you want to?
No, I'm talking about actual production. We've got original music that it's not licensed anywhere. It's that personal music and songs, those types of things, cultural type of things.
So can I
And
just
we
say,
do have a
Joe,
waiver from that art person.
Joe, I
Which
just want to say,
creator inherently has a copyright in that music.
Yeah, that was my point initially, is that as soon as pen to paper, they have a copyright. They may not have registered that copyright, but they own the music. So they must be licensed, or you must get permission.
yeah. So what we do at our station, if it's an independent artist, Joe, is either by email, not a phone call, but by email or something, statement saying that they know it's going to be recorded and distributed. That the person, the performer, the artist, the musician, just a simple statement, a couple of sentences saying, I'm giving permission for this to be recorded and distributed. And that's the specific language we use in addition to being broadcast. So that's the
I
permission.
think it's good journalistic practice to
Very
do that too when you're interviewing somebody. So when you're doing an interview, to start out by saying, you know, that we're recording this and we want to put it on the air. That's just good practice altogether to do that.
Correct.
I might
Yeah,
ask,
that's done.
just as a kind of the picket fence, I might in that statement, Isabel, or anyone, put a duration of time that they're giving you permission to use it, and in any capacity. Because here's the interesting thing about copyright law. Musical artists actually have sort of extra powers versus choreographers or painters or what have you, because all of that's intellectual property that can be protected. Performing artists and composers do not transfer rights to anyone unless it is expressed clearly in writing, versus, you know, you get a email from your aunt's best friend saying, can you paint my daughter in like 19 things, and you do it, or you take photographs and you think you own the negatives. But no, if you're a visual artist, that automatically, those negatives would automatically be owned by the person who paid you to do it. But if somebody asks you, I want you to write like a melody for my wife at the wedding and we're going to sing it, blah, 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 that music stays with you unless the contract specifies that that tune will be owned by the person who paid you to do it. So in the context of asking for the right to use the music and the recording of it, that you can distribute it in whatever capacity, I would just put it, just to protect yourself and to be clear on the expectation, that you put a duration of time on it.
A good
Next
recommendation.
year, for the next 2 years, you know, just something that it's like, what is it? How long is it? Who the individuals are that are playing on it, and how long you have it for. So scope, time, parties.
Make it as long as possible in any medium possible.
In perpetuity.
Exactly. That's why we don't. That's why we don't.
You want to balance it. You know, you don't want to say, hello, we get to use it for all, you know, you're a college kid. You don't know if it's going to be great or not, but you want to feel that you're supporting them. So you could be a bully, be Disney, and say, I want everything forever in all forms of media, invented now and for all time into the future and infinity. You could do that. But, or you could say 4 years, you know, like that. You decide.
All of this is
Ours,
talking
we've
about,
got it.
all of this is talking about an original artist performing an original work. Now, if
Right.
they're performing work that belonged to somebody else and is under
a whole other
copyright,
ball
you've got a
game.
different story altogether. They can't grant permission to reuse that work.
It's a Harry Fox problem. Yeah.
Because the recording studio owns the rights, right? Not the artist?
Well,
Composer.
however they went, yeah.
Composer owns the rights to his own work. So again, it's that birthday cake, composition, performing artists. It's a layer cake. And then you have the publisher and you have the label, you know, it spirals out. But the very, very first set is who wrote the music and who's performing the music. 2 sets.
What are the consequences of, say, Joseph wasn't at this meeting today and he didn't realize he couldn't post this copywritten information on his website? What are they going to do? Are they going to come to you and say, please remove it, send you a cease and desist? Are they going to start fining you immediately? Does anybody have any?
I'll send you a big bill.
They will.
Ignorance is no, you know, is not a protection. You
They
know.
won't give you a cease and desist first.
Yeah, and you know,
Sometimes
I have to
it
tell you,
can, but
there's a new type of business going around where people actually make it their business to find this and mediate between you and the owner.
like personal injury. Yeah, I know it's not.
And
Got it.
there are actually sharks out there looking for opportunities. We just got nailed. We had copyrighted images on our website and we went through a lengthy negotiation and we're happy to get away with paying $1,300. It sucked, to put it mildly, but this was their business. So I'm sure it's happening with music too.
And maybe this is something that John could speak to, is there's an organization you can sign up with that can help you alert you when you have something that you need to take down.
Yeah, there's a
Like $6 a year.
DMCA. I think I actually put it in the document that I send around.
Yeah, you did.
And you pay like $6 a year, as Stephanie just said. And what you should do is create a group email if you can, so a number of people see it, so it doesn't get missed, because as Ursula said, it's pretty expensive. And there are these people called scrapers who, that's their business. They use different services, whether it's music recognition or whether it's optical recognition software, to look at people's websites. And if they can find something, they will contact the copyright owners. And, you know, it's expensive. So, you know, I would sign up, you know, with it. Pacifica has signed up. All of our websites in Pacifica are under this, and we have a group email. So, you know, so we're, you know, if there is a complaint, if there is a takedown order, we will be able to handle it, you know, right away and not miss it with any luck.
Does this apply to like posting album arts and that type of thing on socials?
You can't. That's one's music. Art is something else. I mean, who is this? I'm sorry, I don't mean to. Eddie.
Well, my name's Eddie. I'm a KCR. For instance, if we post the album art of an artist onto social, it doesn't apply in the same way?
No. What's your thought on that? I would say no. Different set of rights, different artist. I mean, you might have an album for, I'm going to make it up, Stevie Wonder, but the artist who did that work, maybe it's owned by Stevie, maybe it's still owned by that artist. Visual art. People have asked me for many times if what they find on the internet is quote unquote public domain. And I'm not presuming that anybody's confusing it here, but just because an image is accessible doesn't mean it's automatically permission to use it. So I would exercise caution with those images.
But if you are an LPFM and the nearest gas station or dollar store is 25 miles away, I'm not sure it's worth worrying about any of this until somebody complains.
That's That's what a few stations I think function under. And my impression, not my station, we don't have any archives online. But they just wait for the letter, take it down, and then they take it down and move on.
You
May
can
not
do
be
that
the best way
until it's repetitive. You know, it's the known or should have known. It might be fine the first time.
Right.
But if there starts to be a proliferation, then you open yourself up to much greater potential liability, I think.
So I have a related question. So with our newsletter, we've started putting in it links or the music director's top picks for the month, right? With a link to the artist wherever it may be posted. So it could be an independent artist, could be a licensed artist, but wherever they have their stuff posted, if they have it on Spotify or Reverb Nation or somewhere else, including that link directly to Reverb Nation, Spotify, whatever, including a picture that is with whatever that link is. Anything else, if they use a picture, you know, they have to, you know, cite whoever they got that photograph from. But you think there's any issues with that since it's already published? We're just reposting what they have published, helping them promote their album art or whatever.
Sorry. No, not good.
Not good.
Not good. Which is part of the problem. Let's put it this way. There is always, and people have asked me and many of these things like, well, fair use, fair use, fair use. Okay, fair use. There is a fair use for those of us that are aware of this term is a carve out where you admit that you are infringing, but because of the type of infringement, you are not liable, financially liable for it. Okay, one of those, which is the most common example, is again, my brain isn't working completely today, is when you mock, you're mocking something.
Satire.
Satire. So you hear a song and you mock the song and criticism, parody, right, is part of, it's like you admit that you're using the music or the image, but you're creating, you're not just setting funny words to the same song, you're actually creating a parody of the meaning and the expression in the initial. So you're mocking itself. If you were to just make up funny words, you'd be guilty and you wouldn't be protected.
Yeah, so I'm not...
Images. This is what I wanted to get to.
Yeah.
There is a carve-out called newsworthiness. It's like, oh, this is an up-and-comer. There's an image associated with this up-and-coming situation. I am going to use this image to help it promote its newsworthiness as an up-and-comer, but you don't get to do that forever. And the common thing that I've seen, and again, this is not in stone, a couple weeks. So if you something's a new release, you want to be part of the excitement around that release, you can use the image and small window of time. But if you were a year from now to say, I want to print a retrospective of all of these things that we have compiled, you wouldn't be protected because it's no longer newsworthy.
Right. So I guess, so maybe I wasn't clear, or maybe it's just a long answer too, but so the artist is giving us the music, they're giving us the promotional material, they're giving us the digital links that include their promotional materials. So if we were to say repost it on Facebook because they sent it through Facebook, as opposed to resharing it through our newsletter.
Are they giving you something in that promo packet that says
so they're giving us
warranty? But here's the thing, it's very fine point, but an important one for you because you're a big institution with big pockets and scrapers will look for this.
Yeah.
You have to make sure that in your promotional packet, they are warranting that they own the rights to all of the materials, including the photographs in that promotional packet, and therefore giving you the rights to use it. But they are warranting that they have taken care of.
Mm-hmm.
And then they give it to you. Yeah, use it for free. I have the right and I'm giving you permission. You know, they're warranting that you are protected from any issues pertaining to any kind of infringement about the images.
Yeah. So I'm thinking, for example, everything used to come as paper, the liner notes and the promotional materials, it was all paper. Now it's digital.
The same thing.
That's what we're sharing.
The same thing would apply. Sorry about that. I'm sort of talking too much here, guys. I don't mean to. Shutting up now.
No, that's fine. That's
Complicated issue.
The New York blabbermouth in me.
No, you've been a great help.
I saw that Elliot had a question early, or sorry, Eddie. Windows changed. Is Eddie still here?
Yeah, it was my. Yeah, it was just.
Was that the same one that you asked?
Hey, Eddie.
Yes.
Okay. Okay.
I know it's frustrating, and I know it would seem intuitive to say I'm using the album, so I want to display the album to support the music that I'm working. But it's unfortunately requires, it's a little more complicated than that.
Yeah, apparently.
I wish the artist would say, yes, here, promote my album, and here's the disclaimer, we've taken care of all of these rights for you. But a lot of them don't, and that's
So
why
look for that. Look for that.
caution.
Look for that disclaimer on the materials that they're sharing, whatever it is.
Exactly.
Yeah, it's bizarre. I know. I believe you see Santa Barbara Radio was hit with a cease and desist from sharing an album art for like a review.
I mean, I've worked with artists who have asked me to do like almost like merchandising contracts, because they don't just want the art for the album. They want to be able to put it on hats and t-shirts and mugs and sell it on tour and this, that, and the other thing. And they need to have an agreement with the artist who maybe did it as a work for hire, but maybe didn't, just did it in general. And then the artist saying, we want to now control this image and have it be part of our branding adventure, in search of a better word.
Thank you for that.
Did you have another question, Isabel? Or
I'm wondering, you may not have an answer though, but what about just sharing the link and then it links over to whatever promotional material the artist has?
Or maybe to a YouTube or something.
I mean, I would be very cautious by linking, because you want to make sure what you're linking it to isn't its own infringement. So you want to make sure that that's an artist authorized link. It isn't just somebody else linking from something, because that gets
right.
But I think publishing a link is not the same thing as, okay, here's an interesting question, and I haven't run into this, but I've always wondered about it opening up a door of liability, which is you publish the link, but you don't create a hyperlink. You just print all of the characters, the .com at the end. That I don't think is a problem. Once you actually create the hyperlink that sends them from your site to someone else's site, I still think you're okay, but I've never had to actually do research on that particular level of engagement.
Good question too. It's a good question too.
yeah.
I think what Michael was saying here, you have to be really careful about what's called a copy. Copying something could be as simple as when something comes on your screen, software comes on your screen, the code that presents that software, that image, is a copy by law. So that creates problems and interesting infringements in the software world. Okay. In the context of music, once you have downloaded the performance and have an MP3 file, an MP3 file is a copy of a live performance. It's also a copy of the music and the performer. So there's performance rights associated. That's a copy. But whether the link creates a problem, I would argue no, but it's a very good question.
Anyone else have any questions along these lines, or any lines?
Well, to wrap it up here, I would caution people, do not allow yourself to be driven crazy by this stuff. What is the worst that can happen? Somebody can come around and accuse you of a copyright infringement. Now, that's a serious matter that carries statutory penalties and even perhaps attorney's fees for the complainant. But hey, if you say, I'm sorry, I had no idea, it is not going to be a capital case. It is not going to be a judgment into the 5-6 figures. No, it is not going to put you out of business. So this, of all the things that you might lie awake worrying about in this day and age, I think this is not one to worry about all that much. All you can do is try to act in good faith to comply, and that's it.
Oh, Thank you, Michael, and thank you for joining us. I have one more question, and tell me if this is off too much in the weeds, but can anybody tell me the guidelines of taking a news clip and including it in a show? What are the parameters of, say, or either a news clip, or like, for instance, the other day we used, Stevie Wonder made this this video that he put out, I guess on YouTube and other places, announcing that he's sick of the United States, and we used that in a radio show, and I don't know whether we were allowed to do that or not.
I think it comes down to that fair use newsworthiness thing, right? Isn't that, I mean,
So
I
if
think
it's newsworthy,
thing.
so
Yeah,
if
but
it's newsworthy, you can do it.
right. I mean, I would, what I tell people to do is think about it like this. Newsworthiness is something that's it underscores a public policy that we want to educate and inspire the citizens of the United States. That's what all of this is, a balance of a monopoly. It's like we need to provide artists and inventors an opportunity to make a living, but we also want the works that they create to inspire further creativity. So it's this balance, and maybe 70 years, 75 years, thank you, Disney, is way too long to justify that, but that's sort of where we are today. So these carve outs, these fair use carve outs, are underscoring this policy of when do we allow the rights of the inspiration or a public policy to supersede the right of the artist or the inventor to make a living. And in the case of a newsworthy event, pictures of 9/11, people falling and diving off the roof. The first 2 or 3 weeks, that was everywhere and it was fine. But a year later, that image is going to be owned, and the person who took it is going to be able to sell prints of it. Okay. Now, in the context of a quote from an artist, it's either outrageous or it's inspiring, or it's like, I'm walking away and I'm moving to the Caribbean because I can't stand, the politics of the United States. That is going to be of interest and newsworthy for a couple weeks, but not 6 months from now necessarily.
So if CNN has if I take a clip from CNN, they're not going to come after me and say that belongs to us?
If it's in a really tight time frame. The only distinction I would make, and it's only because I've seen people get burned by this, are the sports broadcasters. They keep a really tight rein, and they are constantly pulling things off of YouTube within a window of time because their advertisers are given exclusive rights to be associated with the images related to that sporting event. And maybe they've worked their way through the federal court system. So, what happens to the New York Giants is not considered newsworthy at such a way that's going to impact civilization. And so maybe they don't, that sports outcomes are not considered of the right kind of news to afford people who replicate those protections. Just saying. But something like that's why you have to look at it in the lens of, is this thing that I'm disseminating going to going to participate in this sense of newsworthiness to benefit the world at large in the United States? And what is it going to be? Pennies? Are we going to fight over this? But this is, if you're in the context of you're teaching an intern, or you're teaching, you're engaged within a world supporting creativity, and you're there to help support artists, you also have to, part of that is to respect their intellectual property rights. So, my general feeling is we're all in this together, and we're finding a way to help each other make a living and be part of the dissemination of creativity in the context of this copyright scheme, which was only there to really allow artists to not have to sell insurance while they were doing their thing, or teach school, or whatever people did in the 1920s, 30s, and 40s, before TV and when radio was really the name of the game. So I does that help at all? I know I'm talking a lot here, guys. This is late in the day, and my coffee is racing.
Well, thank you so much to both of you for your wrangling with this. And John, maybe we can continue I know, Michael, you probably need to leave. I really thank you for joining us.
Yeah,
That's
thank
a
you.
packet of
Sure.
information too. That was amazing.
Yes. Yes, thank you, Diana and Michael and John. This has been invaluable. Really appreciate it.
John, you haven't spoken. Is he still here?
Yeah, I'm here.
Do you
Can you hear me?
have any, can you add some more to this? Because you haven't really spoken that much.
I think that they covered things pretty well. If there's something specific you want to, ask about, I'd
I
be
have
glad
one
to.
little thing to add to the last conversation, if that's okay, to ask about. I really like what you were saying, Diana, about that makes sense about having it. You can have a news clip if it's timely regarding to an event to add to the education kind of everyone. I was my understanding when I was reading about that stuff too was that it has to, you don't just want a news clip for like 20 minutes. You want a little clip and then your analysis or whatever, so you make something new.
Ah, there is a criticism carve out as well. So the newsworthiness, like the photograph at 9/11, okay, or that would be newsworthy. It's not critical. It's not criticism per se. It's an artistic expression of an event that has newsworthy import. If you wanted commentary about an event, that's like you're talking about something called transformative use.
Okay.
Okay, and that's there are a lot of avenues of that, particularly in the realm of visual art that we can talk about offline. But if you're discussing the event and it's doing an op-ed piece or opinion of it, then you're commenting on a fact, a historical occurrence, and your words constitute the new transformed piece of a creative work that has its own copyright associated with it.
Oh, okay. So those are two separate.
Yeah, two separate kinds of fair use adventures. One is the newsworthiness, another is the criticism, and the third is something that has its own copyright, which is something that has been sufficiently transformed from the original to have gone past, created its own work eligible for its own copyright protection. And that's a harder analysis, but we can, again, talk about that offline if you want. But
Yeah, there's a question here in the in the chat about whether you can use the headlines from an AP story or something. You certainly can use the headline, and even though you're not a subscriber to AP, you could quote a sentence, I think, from the story. Or according to AP, this, and this. That's fair game within the basically news and public affairs coverage. Another example is if you're at a Senate hearing and there's a mult and several news organizations are recording the hearing, you could use the senator's statement as it was recorded by CNN without any problem. I think no one would really know.
Yeah, how do they prove that?
How you got that anyway. Or if there's a senator who's standing in front of 15 microphones and you take that feed and use it, especially if you use it for a short while. But what you can't do is take the CNN pundit making a statement, recording that statement and reproducing it, unless it's clearly newsworthy in some unique sense, which, these people almost never make any news.
well, I mean, that's like a right of privacy that goes along with the person who's an individual, and then the politician who one presumed based on the nature of their role as a politician, whose words are required to be disseminated for the public good. So there's two dynamics going on here. And in fact, politicians have sued media sources for language that they have used in the context of their private life. And so there is actually case law that speaks to, let's say, corporate executives. It's like, as a spokesperson for Procter and Gamble, you get to comment and use my words as I am a business pundit in this realm, but you don't get to talk about me and my kids and my 15, dalliances and where I like to go on vacation, because that's in my private sphere. So that's sort of a right to privacy slicing and dicing of rights. But he's very, also titles generally are not copyright protectable, but they can be trademarked. So that's sort of the realm where your title, your headlines get sort of free dissemination, if you will.
And kind of similar to what you were saying, Michael, if your producers download music from YouTube, they should not say so that they're doing that on the air, right?
Who
Go
knew?
check this.
Who knew?
Now they'll say things like, "Hey, check this out on YouTube. This is awesome," Right? I mean, they shouldn't really say anything like that, right?
The Wild West.
No comment.
Okay, yeah, I think that speaks for itself.
I hate saying anything that discourages freewheeling speech. Maybe you see what happens later. So, okay.
John, do you have anything to add?
Well, I was just going to mention, because they said titles, but Super Tuesday, I think, is one of the exceptions.
Oh, that's like a trademark thing. Yeah.
Yeah.
Once it's
Yeah,
trademarked,
you have to be careful about that. Yeah.
What was that thing that
Is it the same with the Super Bowl too? You can't say Super Bowl.
It's like I said, it's the Wild West, and you'd have to look at
Each specific.
who's trademarked it. Who's trademarked it. I mean, it's a trademark can be a sound, a trademark can be a scent, a trademark can be a slogan. That has been used to a degree where it becomes the reflective of the source or origin of the creative material. So a trademark is a very different world than copyright. Copyright protects the artist and the creativity. Trademark protects, it's like consumer fraud protection. It's like it protects the consumer from misrepresentation of the source of the products or good or entertainment or what have you. So it's a very different universe.
Gotta run.
It's a big universe.
Oh yeah, big people with big brains and a lot of time and hopefully some money.
Thanks everyone. And Diana, so much grateful that you were there too. So.
Oh, thank you for having me. And I'm just thank Norm, because I was here, grappling with, unhappy clients and the usual. And Norm sent me. For some reason I thought this event was going to be held on Saturday. I was just like, oh my God, it's in 15 minutes. Let me find that Zoom address. So
well, so glad we could have you, Diana and Michael and John. I'm just gonna
usually have better hair.
And thank you everyone for joining us today. It's always good to see you. And until next time, have a great Thursday.
You guys take care of yourself. It's 5 o'clock Eastern.
So Joseph, I think the answer was okay, because you were saying that your musicians own their music, right?
Well, yeah, they're all personal songs.
Yeah, so you're okay because they can give you the right.
That one, yeah. I got some great information here. Thank you very much. This is a good discussion. Thank you.
Yeah, it's just incredible, the whole thing.
It's big.
Oh my gosh. Thank you so much, Stephanie, for putting this together.
Yeah, thanks for adding to it.
Yeah.
And John, thank you for your document. That I think that's going to be a really great resource for everybody.
Definitely.
Yeah.
Although
I'm
Diana,
going to be listening to the
publish
earlier bits when you upload the video. I'm going to be listening to it and seeing if I have to make any modifications or add anything. So thanks to Diane and Michael.
Yeah, there was a modification, John. Diana pointed out something
It was about
reviews.
public domain.
Yeah, when public domain happens, it was complex, to put it mildly.
Did I get it wrong?
She says it's changed.
Yeah.
Oh, okay. All right.
It probably was right at some time, but she says it's
Yeah.
changed.
Yeah, well, it's difficult to keep up with everything. Today I saw an article about GMR and commercial radio, and that may actually affect non-commercial also. So they're asking for more money, and that's, you know, if you're under CPB, if that's how you pay for the PROs, then you're probably okay. But if you're not, you have to factor in GMR. So they're the new kid on the block, and
What
it used to be only a buck.
What is GMR?
Global music rights, maybe. It's like BMI or ASCAP, but it's the new kid on the block. They were only getting $1 per year up to this point, but now it seems like that may be changing. So.
All right. Sounds like fun. I'm sure they'll contact us.
Yep.
I'll let them call me. We won't call them.
Good deal.
Okay.
All right.
Thank you so much.
Okay. Yeah. Thanks again, John, and thanks
All right.
everybody.
Sure.
Okay.
And check ya on the flip side.
Yeah.
Yep.
Bye-bye.
All right. Signing off.
Take care. I know.
Bye bye.